I think I was young enough, naive enough, and ambitious enough to think that I could do my job better if I did it by myself. When we co-founded Claritas in 2022, nobody had done that in Cayman. So we were the first.
Where are Cayman Islands? Why we have so many litigations, court proceedings there?
So the Cayman Islands are in the Caribbean. We're very close to Cuba and Jamaica and just south of Florida. So Chinese clients use Cayman companies a lot. They particularly use Cayman companies when they have a business in China which ultimately they want to list, particularly on US stock exchanges. So a lot of the Chinese company disputes that I see are either listed companies or they're companies that were set up in Cayman because they wanted ultimately to list. That's relatively typical of our practice, working with lawyers in other jurisdictions, so US, China, trying to put together the puzzle of where the assets are.
What is the basic attitude of a Cayman Island court towards the recognition and enforcement of foreign jurisdiction court judgment?
So the Cayman court's always going to want to help a judgment creditor or an award creditor if you have an arbitral award from China, particularly if you can show that the debtor is not complying with their obligations. So the court is certainly sympathetic in terms of recognition. So sometimes the threat of a winding up petition can be enough to encourage a recalcitrant debtor to pay. It's our nuclear weapon.
So nice to meet you, Katie. And thank you very much for joining me.
Thank you for inviting me.
So what time now is it?
8:30 in the morning.
So are you at home or in the office?
No, in the office.
I'm right now in my apartment. This is used to be a bedroom, so I decorated into a studio. How is everything?
Yeah, it's all good. It's been quite a busy start to the year for us. I'm going to be back in Beijing next month, as I mentioned, so hopefully we can catch up again then. But yeah, it's all good. How about with you? You must be preparing for Chinese New Year.
Yes, and I'm leaving for my hometown the day after tomorrow. Who are you and what do you do?
So my name's Katie Pearson. I'm the co-founder of Claritas. Claritas is a boutique law firm in the Cayman Islands. We practice litigation, insolvency, and regulatory law.
What made you start the business of your law firm?
So before I started Claritas, I was a partner with Harney's, which is one of the global offshore law firms. And I was a partner in their Cayman litigation team. And I think I just got to the point of thinking that I could do my job better if I removed the apparatus that comes from being in a larger law firm and started from scratch, building a firm that was specifically targeted to litigation. So, litigation is different from other areas of law. So one of the things that was driving me a bit mad at Harney's was the conflicts. So being a litigation-only firm, it's great to be part of a small firm, single office. We're rarely ever conflicted. From acting for clients, we can act against big institutions, and we can also clear conflicts really quickly in a matter of minutes. So I think I was young enough, naive enough, and ambitious enough to think that I could do my job better if I did it by myself.
Wonderful. What are your challenges or obstacles you need to overcome to start your own firm?
I think that the main obstacle is just having the confidence, to be honest, to take the leap and to actually do it. I think a lot of lawyers think about it and dream about it, but not so many actually take the step to actually do it. And then once you have kind of taken that step, there's quite a big administrative burden. When you're working in a big firm, you see all of the obstacles and the things that stand in your way, like the conflicts, but there's also a lot of stuff that's being done for you in the background that suddenly, once you have your own firm, you have to do that for yourself. You have to be all over a lot of different aspects, not just of doing the legal work and not just of doing the business development and promoting your firm and winning the work, which is obviously a hugely important part. But there are all these other aspects like the financial side of the business and all sorts of getting it licensed, getting it insured that you wouldn't have had to deal with when you're working at a big firm.
How is the competition there among all the litigation firms in Cayman Islands?
So we have a lot of law firms in Cayman. So when I started Claritas in 2022, there was kind of two sorts of firms in Cayman. So you had the global offshore firms like Harney's, Appleby, Maples, Walkers, who are full service firms, and they have litigation teams, of course, but for most of those firms, litigation is not the main focus of the firm. And then you have local law firms who don't necessarily cater that much to the offshore market, but would do local work like employment work for people that are actually living on the islands. But when I set up Claritas, there wasn't a litigation boutique firm. So in London, certainly, and in the US, and obviously you guys did it as well with Tiger Partners, a lot of people have broken off from the larger law firms to set up litigation boutiques. And when we co-founded Claritas in 2022, nobody had done that in Cayman. So we were the first.
As a pioneer, how do you attract your clients? Or in other words, why clients choose you over other larger law firms?
We're not going to attract every client. For sure, there are still some clients that would want to go with the larger firms, the trusted brands. But I think we offer some advantages over the global firms. So being a boutique, we have a small team, but a very focused. So our lawyers on the commercial litigation and insolvency side have all practiced in the global offshore firms. So they're the same standard of lawyers as you get in those firms. One of the complaints that we frequently hear from clients about offshore firms, and including Cayman Islands firms, is the cost. And often the cost comes from having really big teams on matters, particularly matters for Asian clients, where the client would come initially to the firm's office in the PRC in Shanghai or in Hong Kong. And then that office would have to get the Cayman office involved. And suddenly you have, maybe 6 people working on the matter in the offshore firm. And that leads to all sorts of inefficiencies, and it's obviously highly expensive. So our aim was to create a firm where we'd have a small team based in the Cayman Islands only. And when we're acting for Asian clients or particularly Chinese clients, we want to partner closely with the Chinese law firm and cut out the kind of middle office of the offshore firm having an office in Asia itself. We have lawyers, counsel level lawyers. We have an articled clerk at the moment who's just finishing his training. And we have a secretary. So we have, support at the various different levels. Yeah, the one big advantage of being a litigator in the English common law world is that we can also, where we have larger matters, and we have done some very big matters, we bulk up the team with barristers from the London Bar, and we work closely as a team with them on individual cases. So that just gives us the flexibility where we need a larger team. We can easily build a really good team, but we don't have a lot of people sitting around idle that we then feel the pressure to put a massive team on every case.
So are you working remotely or you come to office?
We have an office. We actually, we didn't have an office for the first few years of Claritas' existence. When we first started, we didn't know what our workflow was going to be like. So we didn't get an office initially. Everybody was working from home. But last year we moved into our first office. And I have to say it's really made a big difference to the team. I think it's really important to have a place where we can actually work together and collaborate, especially as the team is growing.
Is it popular for Cayman Island courts to have the online hearing? Because it's quite popular now in China.
It was popular certainly during COVID. Our court immediately switched online pretty seamlessly, actually. So for that COVID period, a couple of years or however long it was, all of our hearings were online. But now that that's the courts generally sit in person. The Cayman attorneys are expected to go to court and appear in person. The court does use Zoom to record all of the hearings. So where we have clients overseas, the court will typically give them permission to join the Zoom link so that they can dial in and hear what's going on and see the judge and everything in real time. But typically the Cayman attorneys are expected to go in person.
Where are Cayman Islands? Why we have so many litigations, court proceedings there?
So the Cayman Islands are in the Caribbean. We're very close to Cuba and Jamaica and just south of Florida. It's a British overseas territory, so it's ultimately subject to the King of England's jurisdiction. We have our own legislature which passes our own laws, but laws ultimately have to get royal assent, so they have to be assented to by the governor, who is the representative of the king in the Cayman Islands. We have our own court system, so the Grand Court, which is the Court of First Instance, and the Court of Appeal both sit in the Cayman Islands. And then our final Court of Appeal is the Privy Council, which sits in London. And as to your question, why do Chinese clients have so much litigation in Cayman? So Chinese clients use Cayman companies a lot. They particularly use Cayman companies when they have a business in China which ultimately they want to list, particularly on US stock exchanges. So a lot of the Chinese company disputes that I see are either listed companies or they're companies that were set up in Cayman because they wanted ultimately to list, but by the time that the dispute arises and they come across my desk, the listing hasn't happened yet. And obviously a lot of them, they aim to list, but they never actually get to the listing stage. Cayman's also used a lot for hedge funds and investment funds. So we have a lot of hedge fund disputes here. And it's also used a lot for trusts and private wealth holding.
What qualifications do you have to get before you can practice law in Cayman Islands?
So there are two different routes that you can go. The route that I took was I qualified in England first. So I'm originally from England. I did my university and law school in England, and I trained as an English solicitor with Freshfields, one of the Magic Circle law firms. And then I practiced at a firm called Peters and Peters, which is a niche fraud litigation firm. And I moved to Cayman in 2009. I thought it would be fun for a couple of years. But the longer you stay here, the harder it is to leave. So 17 years later, I'm still here. So if you're already qualified in England or an equivalent jurisdiction, it's relatively easy to get admitted to the Cayman Islands bar. You have to have 5 years post-qualification experience in your jurisdiction of origin, and you have to be resident in the Cayman Islands, and then you can apply for admission to the Cayman Islands bar. Or if you're Caymanian, can do your law school. We actually have a law school here in Cayman. It's part of the University of Liverpool, an English university. They do the same. So the law school here does the same exams as the students in Liverpool in the UK. You can do that here. And then you can do your articles, your training with a Cayman Islands law firm. That's an 18-month training period. And then you can get admitted to the Cayman Islands bar at the end of that. Those are the two routes, training here or qualified and getting your 5 years of experience somewhere else and transfer.
So would you give us example cases you handled, especially involving the Chinese clients or Chinese counterparties?
Cayman Islands is a jurisdiction, basically a jurisdiction where people set up companies, and Chinese clients use Cayman companies a lot. So one of the big pieces of litigation that we've done was acting for a Chinese ultra high net worth individual who had invested in a Cayman Islands hedge fund and was in dispute with the management of the fund. He started by seeking to wind up the fund, and then the manager, that application was ultimately unsuccessful. He was represented by a different law firm at that point, and then he came to us after that. And after the initial litigation had failed, the manager kind of went on the attack, and he was basically the defendant to two separate lawsuits in Cayman, which ultimately we were able to settle and get him a very good result. We also do a lot of fraud and asset tracing work. So one of the cases that we worked on, we were acting for a Chinese company that had lent money to another Chinese company, guaranteed by the principal of that company, who I described in my submissions to the court as a former billionaire, because he used to be on all of the Forbes rich lists, but then fell off the rich lists after a certain point and stopped paying his creditors. And our client had got a judgment against him in China and had engaged a US law firm which had done a global asset tracing exercise to try and find out what he'd done with all of the money. And as part of that exercise, they'd identified two Cayman Islands companies that they thought were beneficially owned by him. And so we were engaged to make an application to the Cayman court to get a disclosure order ordering the registered officers of those companies to disclose the beneficial ownership information that they're obliged to collect. That was an interesting case. Ultimately, we got the orders and the registered offices provided the disclosure. That's relatively typical of our practice, working with lawyers in other jurisdictions, so US, China, trying to put together the puzzle of where the assets are.
Brilliant. So speaking of the enforcement of like China court judgment, what is the basic attitude of a Cayman Island court towards the recognition and enforcement of foreign jurisdiction court judgment?
So the Cayman court's always going to want to help a judgment creditor or an award creditor if you have an arbitral award from China, particularly if you can show that the debtor is not complying with their obligations. So the court is certainly sympathetic in terms of recognition. So it's different for judgments and arbitral awards. Arbitral awards is easier because we have a statutory framework for recognition. Judgment, we do have a statutory framework, but it's only ever been extended to certain Australian courts. So for judgments from anywhere else in the world, including China, you have to seek recognition under common law principles. So it certainly can be done and is done, but it's not quite as straightforward as with an award. What we actually often do, so you can certainly get a judgment from overseas, including from China, recognized, and then there are various orders that the court can make in support of enforcement, including appointing receivers, charging orders, garnishee orders. Often the more direct route to enforcement, and the route that we more often take, is simply to issue a winding up petition. If your judgment debtor's a Cayman Islands company, you simply issue a winding up petition on the strength of the overseas judgment or arbitral award. And if the petition's successful, then liquidators are appointed. They step into the shoes of the directors, take over the running of the company, collecting the assets and distribute them to firstly the creditors, and then if there's anything left over, to the shareholders. So that's often the easier option. It's also, if the company is actually operating and still needed, it's not something that the directors want to allow to happen. So sometimes the threat of a winding up petition can be enough to encourage a recalcitrant debtor to pay. It's our nuclear weapon.
You have worked with many Chinese clients and Chinese lawyers. What are the main differences between litigation in Cayman and litigation in China that the Chinese client or Chinese lawyers should be aware of?
So I think the systems are actually really quite different. So Cayman is a common law legal system based on English common law, and China is obviously a civil law system. So my impression is that in Cayman, there's a greater burden on the parties and we have less judicial intervention. So I understand that in China, for example, in relation to enforcement, the judges are quite proactive and can go ahead and search for assets and then freeze assets, whereas in Cayman, we're sometimes asked by clients from China or from other civil law jurisdictions, okay, we've got this judgment, can we apply for enforcement? They always have to say, well, no, actually, there's no such thing. It's up to you as the creditor to go out and find where the assets are. And then, yes, once you've identified, specific assets, yes, there may well be legal routes that we can use to get control of them, but it's very much like the burdens on the creditor rather than the judge having the wide-ranging powers that they would have in China. One of the other big differences is I understand that in Chinese litigation, there's no general obligation of discovery Whereas in the Cayman Islands, if you're in litigation, there's an obligation on the parties, each party, to provide to the other party any document that's relevant to the proceedings. And that includes documents that are helpful to your case, but it also includes documents that are unhelpful to your case. And there's an obligation as well, as soon as litigation's in contemplation, to preserve relevant documents. And it's a really very heavy obligation, and the court really does not take kindly to any suggestion that a party hasn't complied with that obligation. So I think that's that's a big difference, and something that some Chinese clients find it hard to understand.
Discovery procedure is kind of pain. It's quite annoying.
It's really annoying. It's really expensive. It's a lot of work and it takes a lot of time. But if you don't if you don't comply with your discovery obligations, like in the eyes of a Cayman judge, that's pretty much the worst thing that a party can do. It's very risky not to comply. And ultimately, at the end of the day, it's an obligation not just of the client, but of the attorneys as well. So if we're acting in a piece of litigation and we know that our clients, if our client's genuinely refusing to comply, then we would have to cease to act as well. So it's it's something that we take extremely seriously. And that's just, that's your general discovery obligation in general litigation. But a lot of what we do is urgent applications for injunctions. So, for example, freezing injunctions, which are often made ex parte, so without notice to the other side, on the grounds that if you gave notice, it would defeat the purpose of the application. And where you're making applications ex parte, you have an enhanced discovery obligation. You have to give full and frank disclosure of any facts or legal arguments that the other party might raise. You have to, because the other party's not having an opportunity to take part in the initial hearing, you have to basically make the arguments that they would otherwise have made had they been given notice. And I think that's also quite hard for people from another legal system to understand.
We have a similar procedure like this. And I was wondering, how quick can you get this injunction? And what is the standard procedure of that? And is it easy to get that?
If you're applying for an injunction ex parte, you typically have to provide a cross undertaking in damages, which is a promise to the court that if you get the order, but it subsequently turns out you shouldn't have got it, you'll compensate the other party. So, yeah, we have that. In terms of how quickly the applications can be made, we've had a couple of freezing order applications in the past year where we've been coordinating closely with applications in other jurisdictions. So we've found the Cayman court very helpful and very accommodating in terms of getting the Cayman applications on quickly. And we've really written to the court and said, because this other application is happening in this other jurisdiction on this date, it would be really good if the Cayman application could be heard the following day, and we've specified exactly what day we want it to be heard. And in both instances, the court has come back very quickly and given us the exact date that we've asked for. So it takes some time to put the application together, especially if you're going ex parte and you've got your duty of full and frank disclosure, and you've got to marshal not only the arguments that are helpful to you, but also think about what the other side would have said. But certainly our experience recently is that the court will list things very quickly and really is used to operating in a cross-border situation. Pretty much everything that we do in Cayman is cross-border. So if you say, you know, there's a hearing here and there's this happening in there and you need to fit in with that, the court will do its best to accommodate that.
Yeah, brilliant. What procedures are available before a Cayman court that the China clients may not be so familiar with and we could use as weapons in our toolbox?
So I already mentioned the winding up petition, which as an enforcement tool is often the most powerful and appropriate. The other thing that I think Chinese lawyers are not always fully aware of is the orders that the Cayman court can make in support of litigation or arbitration that's taking place in China. The Cayman courts, I mentioned freezing orders and disclosure orders. The Cayman court can make those orders not just in support of litigation that's taking place in Cayman, but also in support of litigation that's taking place overseas, including in China. So that's that's certainly something that's worth being aware of.
Speaking of that, so can I apply for a freezing order when we are now having arbitration proceedings, or I am about to launch the arbitration proceeding in China or before CTAC? Can I at the same time apply for that injunction order in Cayman?
Yeah, absolutely. I mean, you'd have to show that there's a Cayman element to it. So there'd have to be a Cayman company involved or otherwise assets in Cayman. But yes, absolutely, you can do that. So one of the injunction applications that we did last year, we were acting for a Danish pharmaceutical company. It makes Ozempic, the weight loss drug. So before it started the arbitration proceedings in New York, it got a freezing order from the Singapore court and a freezing order from the Cayman court, freezing any monies that were still held by the Cayman company. So that was one of the instances where we had to ask the courts, we had to issue the application very urgently, and we had to ask the courts to coordinate the timing so that the Cayman application was heard on the day after the Singapore application was heard. But yes, that's absolutely, the sort of application that we can do in Cayman and the sort of application that generally the court will be sympathetic to.
How quick would the court issue that injunction order? Like within 2 weeks or within 1 month?
So that one, I think we wrote to the court on the Tuesday afternoon to say, we think that the Singapore application, we're about to issue this injunction application. We hadn't even issued it yet. And we said, we think the Singapore hearing is going to happen on Friday. And if it happens on Friday, please, can we have our hearing on Monday? And then by the Wednesday morning, we had the hearing date from Singapore. So we wrote to the court again and said, we've got our hearing date in Singapore. It's going to happen on Friday. Please, can we be heard in Cayman on Monday? And within a couple of hours, we had the court's response and we had the hearing confirmed for the Monday. And then we got the order the same day. So that's 3 working days from issuing the application to getting the injunction.
Okay, that is quite impressive.
Yeah, well, we had to show, we had to show that there was urgency and there was genuine urgency in that case, because it was ultimately a fraud case. So if you can show, a genuine need for urgency, then the court will respond and act quickly. Obviously, they get quite annoyed if you allege that there's a need for urgency and then when they actually look at it, there isn't. But so long as you don't pretend fake urgency, then the court will try and be very helpful.
Speaking of the winding up petition, what requirements must be met before you can make that petition?
So there are two routes to winding up. You can either have a creditor's winding up petition or a shareholder's winding up petition. So we often use creditors' petitions where we have an unpaid judgment debt or an unpaid arbitral award, often from another jurisdiction such as China. And the creditor's petition is quite a simple route. So typically you would issue a statutory demand first, which is a written demand in a particular form that you serve on the company at its registered office. And then they have 21 days to comply. If they don't comply with that, there's a statutory presumption of insolvency. And that's very helpful because you basically don't have to prove insolvency. So it's a case of, you issue your petition, you have to wait a certain time because the petition has to be advertised both in the Cayman Islands and the jurisdiction in which it's most likely to come to the attention of other creditors. And in order to leave the window for advertisement, which is prescribed by our rules, that means that it probably has to take at least 5 weeks or so from the date that you issue your petition to the date that it can actually be heard. But that's generally, relatively straightforward process. Shareholders winding up petition is more complex. So we often issue shareholders winding up petition where there's a shareholders dispute. So often it's the case that a Cayman company has been used as part of a joint venture, for example, between two parties, and those two parties have fallen out and the minority shareholders have become dissatisfied with the way that the majority is conducting the company's business. So in that case, the remedy for a minority shareholder is typically to issue a winding up petition on the just and equitable ground. So that's alleging that it's just and equitable that the company should be wound up. It's more complicated than a creditor's petition because you have to satisfy the court that it's just and equitable for the company to be wound up. So some of those cases can be heard relatively quickly, maybe within about 6 months. That would be quite an accelerated timetable. And generally, you'd get a quick hearing like that if you could convince the judge that it was urgent. So if you could convince the judge that the fact of having the petition hanging over the company was causing detriment to the company's business. Other cases of shareholder winding up petitions can rumble on for years and years. So that's, it's quite fact specific and quite context specific how long those cases will take.
How is your fee quotation or fee structure? Is it flexible?
Yeah. So we typically act on the basis of hourly rates. That's typical for most law firms in Cayman. We are permitted to act on contingent fee arrangements, but they're not widely used. They've only been permitted in Cayman since 2021. And they're not widely used yet in commercial litigation. So typically it's hourly rates. Claritas as a firm is very conscious of clients' concerns about costs, and we know that this is a general issue with offshore firms. So we will always do our best to keep costs under control. We often agree like fixed fees or capped fees for specific pieces of work, and keep to those fees. I think there is also a kind of education element to it. I do think that with a common law system, the level of the quality of evidence and submissions that our judges expect sometimes takes Chinese clients by surprise. Our judges are really good. I think they're very accommodating. They'll do things quickly. They're used to hearing very high value disputes. But I guess the other side of that coin is that they expect a very high standard from us as well. So they expect us as the attorneys to have really crossed every T and dotted every I and made sure that we've asked the clients all the right questions and that we're complying with our disclosure obligations, including the full and frank disclosure obligation if it's an ex parte application. So my impression is that there is more work that goes into putting together an application for the Cayman court than possibly there might be for the equivalent application in China. And it is more expensive, but if you're dealing with a very high value dispute, it can be worth it because, if you put together a good application, you should get the order that you're seeking.
Do you have any advice to give to potential China clients and Chinese lawyers for the ease of future Cayman litigation, or anything there to avoid?
I think it's just about communication and understanding what the Cayman courts can do, first of all, because I think that could be better understood than it is. And also understanding the expectations of the Cayman court in terms of how applications are put together, the discovery obligations, that kind of thing. I think it's really just about communications, and that's why, we as a firm are very keen to build relationships with Chinese firms and get to know the lawyers. And then you're working with people that you know and trust, and, you're learning about each other's jurisdictions all the time. So I think, my main suggestion would be let's just keep the channels of communication open, and we're always happy to speak to people like you or other Chinese lawyers just to if they have questions about Cayman litigation or a situation involving a Cayman company and they just want to understand, is there something that we can do in Cayman here?
Yes, I totally agree. Communication is the key. I mean, as a lawyer, I deal with a lot of cross-border dispute resolution involving different jurisdictions where people have different cultures. They all have their perspectives. So I do believe that it is essential for us to bridge the gap with the local jurisdiction legal practice and the foreign clients' expectations.
Yeah, absolutely. I would like to thank you very much for the invitation to take part in this podcast with you. It's been a pleasure speaking with you today.
Pleasure's mine too. Yeah, and I would say to the audience that if you have any questions, you can leave your comments below. And also, I will put Katie's email below. Audience from the globe, lawyers from the globe, to connect with Katie Pearson, legal expert in Cayman Islands.
Yeah, absolutely. Thank you, Lee. And you can feel free to share my WeChat details as well if you want.
Yeah, sure. Thank you very much. And also, if you have any queries about the China law and China court proceedings issues, feel free to let me know.